Hello, Prashanti. My
Hello.
wife has an approved H1B from a consultancy. She had a stamping appointment recently and received 221G. Um, Considering the 221G administrative processing would take a lot of time, so I'm looking for alternative options. I'm not sure if this was the first time H1 or they're filing an extension. Um, can I apply for H4 parallelly? Question number one. Can she find a different employer from India? I'm assuming in the US, then transfer H1B and go for stamping again, considering there is an ongoing issue with an existing application at the consulate. Please suggest any other options to bring her to the US.
Right. So when you go for administrative processing, that is usually the problem. They can take forever, and it's like sometimes they just go into a black hole and you don't get any response. I mean, you get standard responses if you send an email to the consulate, and they're not very useful. Um, Congressional help, again, is not much help, even though um, they send out emails as well to the consulate, but they, I think, get the same canned response. So it is a problem, the processing time for administrative processing cases. It's a problem. So what is the solution? Yes, you can apply for a H4. You can presumably withdraw your application for the H1 and apply for the H4. Or even without withdrawing it, you can just apply for a H4 visa. Uh, at the consulate, they might ask you what you plan to do, and you can just orally, or maybe they'll take something in writing. You can, at that point, if they ask you to withdraw the H1, if they're willing to give you the H4 visa, right? You can also apply for a visa again. You can go to the consulate and apply through another employer. I don't see why not. But keep in mind the reason for the administrative processing is key when you're applying for either the H4 or the other H1. If the reason for the administrative processing is something to do with you, the applicant, then you have to make sure that you are able to overcome that before you file for a visa again. If the reason for the administrative processing is something to do with your employer, they're asking some questions, they're not convinced that the employer has a job offer for you, then absolutely you can go with a different employer if you think that the different employer can submit proper documentation which we're not able to submit previously. Same thing with the H4. So it really depends on why your case went into administrative processing.
Okay, so if there was a problem from the employer, I'm trying to understand this. There is a fraud or misrepresentation with the case. Um, is there something to be worried about because the at the consulate the applicant went into 221G. Uh, would that affect their future applications, let it be an H1 or H4 or vice versa? If the problem is with the applicant himself or herself, would that affect, they have, say they have produced fraudulent documents at the time of H1B a visa interview, and which they're probably cross-checking. Now what happens to the following petitions if they have filed for an H4 in this, just like in this case? Can you elaborate a little bit on this?
Yeah. So it's very important, obviously, to submit proper documentation when you're going to the consulate. Because, I mean, if the employer doesn't submit, let's start with the employer. If the employer doesn't submit proper documentation, obviously, that's not on you. So you will not be affected other than your visa getting rejected, which you are affected, but you're not affected for any subsequent visas that you might apply for, right? Because that is the employer's issue. The employer might get into trouble, and then they might have issues even with their H1s that they're filing going in the future. But with reference to you, if you have submitted some fraudulent documentation while applying at the consulate, for example, there was a client recently that submitted a bank statement which then could not be verified by the bank, and he was applying for a B2 visa. And they not only rejected the B2 visa, but they also said he was inadmissible. So now, when that happens, when they say that you're inadmissible, that will lead to a 10-year bar or sometimes a lifelong bar. And you can file waivers if the person qualifies. There are some waivers that can be filed. But in my experience, the consulates usually don't like to look at those waivers because they're not, uh, though they're supposed to, they just brush through them and they don't bother with them. So always be sure not to submit fraudulent documents, because then you could be barred lifelong from applying for a visa again.
So when you said waivers, these waivers are submitted with the USCIS? If yes, consulates are required to.
So it depends on the type of waiver. If the person is filing for a green card, then they would be they would be sent to USCIS first for approval. But there's some non-immigrant 212, based on Section 212, non-immigrant visa waivers, which are submitted directly to the consulate. And again, it keeps changing. The procedure keeps changing. Previously, they could be submitted to CBP as well at the port of entry. Now they're asking those waivers to be submitted to the consulate. So it depends on the type of waiver.
Thank you for answering that question.